Well, good morning, everyone. We're just slightly late in starting this workshop slash briefing. I'd just like to welcome everyone, both joining us in the chambers and anyone who's watching online. Before we start, I would like to make a clarification. I see some political aspirants quoting me as saying I was in favour of pausing the district plan. If they had read the material, we asked for a briefing on the options for the district plan going forward, one of which was a pause. So at no stage have I advocated for a pause of the district plan at this stage. I intend, councillors, to ask for the presentation in its totality, and then we will have questions at the end of the presentation. It's a reasonably short one, so I think that's the most efficient way of operating it. We do have apologies from Councillor McCone and Councillor Linwood, but apart from that, the rest of the DPR subcommittee is present. So, sorry? No, there's no one online apart from Katrina, who's joined us from the UK. So welcome, Katrina. Welcome to everyone. And Mr. Campbell, I'll hand over to you.
Thank you, Mr. Chair. Just part of the formalities, I'd like to introduce Shelley Chadwick and Michael Garbutt from Anderson Lloyd to join us. They've supplied some written material and have a short presentation to run through. Welcome them. I'd also like to acknowledge the 314 groups and individuals that submitted on the proposed plan, some of whom are behind us. And we are working through a two-stage process. One is getting those all into a database through our submission portal. There was probably just under a third used the portal to lodge submissions, which helped speed it up, but we've still got 200 odd to enter. We're just over halfway through entering those, including the ones that are already in there, so it's pretty slow. We've done all the paper copy ones, but we're now getting into some of the meaty digital ones that were emailed in. And the summary of submissions is running in parallel as well. So Mike and Katrina are looking after those. We also acknowledge, and it's probably important just to reiterate that there have been some statements of aspiring political candidates made about the proposed plan and where it's at. So we acknowledge that that is in the public realm, that people are commenting on that as part of their electioneering, but we're here to give advice on the practical and legal aspects primarily. So just probably highlight a couple of things in the paper that I sent through, and it's on the bottom of the second page. I won't go through some of the early stuff, but particularly around the transitional provisions or arrangements. So basically the advice is all coming through from the ministry that plan reviews notified under the RMA are allowed to continue until they're finished. So that's right through to resolving appeals. And the requirement to progress a notified plan is not being suspended by government. So that's an important point, that through this reform, they are not saying halt, do not continue. Some councils like Waimate and Ashburton are not commencing their review. So that's that early part of, do we do a review or not? They're looking at that and getting advice from the ministry on whether they should do anything at all in that early phase. But anything that's kind of underway is allowed to continue. Importantly, any existing plans, whether they're newly minted kind of plans like we're working through, or old plans like Waimate or Ashburton have, would become part of a combined plan under the Planning Act. So what that means is that if you've got a sort of out-of-date old plan, that would kind of get carried over into the new sort of combined regional planning regime. That's important to bear in mind in terms of having something that's current or not in that new framework going forward. The spatial plans prepared under the Local Government Act, and we have a reasonable one for Oamaru Western and Kakinui, would be deemed a spatial plan under the new provisions. Again, we're suggesting at some stage that should probably be reviewed and updated as we had planned anyway. And that's around tracking where growth is going. Is it, meeting what was predicted, or do we need to sort of fast forward some areas? And I'll come back to that in terms of some other recent announcements. The change in planning functions of councils commences on the development of spatial and/or regulatory plans. So that applies to things like the outstanding natural landscapes, features, SNAs, contaminated land and natural hazards. That's signalled that a lot of that may shift to a sort of regional function going forward. And the new legislation will have those sort of transitional details or provisions that direct how proposed plan processes to be managed in the context of these changes coming through. Legal advisors can comment further on that. So what it means for us is implementing a regional planning is going to be split again for us across Otago and Canterbury. We are already in discussions as we work underway with ECAN and the Canterbury councils on how that might look. So there's been a stock take of spatial plans and spatial planning across Canterbury. That is getting ahead of this to say, what do we need to do going forward as a region? There's a meeting early next week for the Otago and Southland councils around this in terms of the staff component, looking at what can happen for Otago and Southland in that space. So we're trying to get ahead and say, what's been done, what sort of work needs to start to be thought about for this spatial planning exercise. So we will still be needing to feed into those regardless of where we're at with the proposed plan, but obviously this process is underway, so we still need to carry that through, whatever form it's in. Our functions down the line will, at this stage, be signalled to be limited to subdivision and regulating land use. And they talk about things like neighbourhood friction, so managing things like noise, shading, odour, glare, light spill, that type of thing, which we already do now. And there's a potential reduction in some of those amenity type effects that people talk about, things like views and that type of thing. When these combined plans and a sort of wider regional natural environment plan gets heard, it's proposed to be heard by an independent hearings panel. So takes away that kind of ability for regions or districts to have any involvement in that hearing of submissions. And the non-regulatory functions of biodiversity and heritage, and potentially others, are to be, I guess, reconsidered in terms of what it means for us. Clearly, biodiversity signal to head to regional level, and heritage at this stage is proposed to go back to Heritage NZ, so come out of our functions potentially. So some quite significant changes there. And we'll need to work through those as the legislation is developed. I guess under that sort of new spatial plan across either Canterbury or Otago, we'll have a bit of one in each camp. This will start to map out things at that regional level, like hazards, as the regions have done, highly productive land, whatever form that ends up in, the significant natural areas, those that are already mapped, and it may pick up others, the outstanding natural features and landscapes, again, trying to pick up what's already mapped, and environmental limits, which is more around the sort of thresholds for water quality, air quality, that type of thing. There'll be provision for the key infrastructure, so roads, rails, airports, ports, obviously included in your spatial plan, so you provide for those and protect them, but also at a lower level, potentially schools, open space and community facilities. So it's picking up the kind of social infrastructure that's needed to support areas. The sequencing of urban development, like we have signalled in the spatial plan, will be carried through. and kind of the arrangement and zoning of activities as we do now. The statutory acknowledgements from treaty settlements. So a lot of our district has those, particularly the water features, and the SASMs would be included in the regional plan. So that would be done regionally. And there's potential to pull in mapping or zoning, or not zoning, but mapping or identification of major existing development for us. That might include Macrae's Mine or Kerry Freezing Works, for instance, where there are already existing zones that kind of provide for them anyway, but mapping in a spatial plan to say these are significant kind of employment and resources for the region beyond just Waitaki. And then there's alignment, obviously, with long-term plans, regional land transport plans, to make sure that the funding and infrastructure can actually serve what's proposed going forward. It's probably critical that happens. So yeah, quite a bit to come in terms of what we will need to be working with our regional and other local council partners on in that space. And I guess importantly, the district plan is trying to get up to date to at least better align with where we want to go as a district to fit into a regional plan, or two regional plans in this case. In the report, we sort of set out some commentary on what's come through in the reform. And I will note that just yesterday, we got notice from the two ministries, Ministry for the Environment and also Housing and Urban Development, that the housing growth component, which was another pillar, is out for comment, and that's due in sort of mid-August. So we'll try and wrap that up in the other national direction analysis and submission that we're preparing for council to consider and sign off. Probably in August now, given the timing of this one, plus we head to sort of end of July, which was going to be a bit of a stretch on getting submission prepared for all the other national direction that's been put on us. So happy to answer any questions for that before we get into the kind of the options that we've been asked to look at, just as a sort of overall overview of some of that national level change. If there's any specific questions on that before we perhaps delve into the detail a wee bit.
Before I go to you, Councillor Blackler, I also should have stated that because this is a workshop, there's actually no decisions made by the committee today. It's an information gathering exercise. Any decisions that this subcommittee would be making would need to be done in a formal setting and referred to council for further action. Councillor Blackler.
Oh, thank you. I just, Mr. Campbell, just before we move on from your last point, do you have any initial comments on yesterday's announcement and how that appears to tie into all the other stuff you've just laid out?
Yeah, thanks, Councillor Blackler. I think some of the key things coming through in the housing one is, and we've already kind of had a bit of a signal on this, is the freeing up of land, particularly the LUC 3 under the National Policy Statement for Highly Productive Land, that's potentially going to disappear, which would push development out into parts of the district or allow for that. The other significant component which we've signalled is they're now talking of allowing for 30 years growth to be provided. At the moment, a district plan is a 10-year document. So what we've proposed at this stage is the first 10 years of the spatial plan, particularly for the Oamaru Western Kakanui area. If government's saying you've got to open it up for even longer, we would then look at going back to the spatial plan and saying what areas were identified there for expanding in those areas, and that would have to then roll over into a planning regime. So that's probably one of the significant things, is allowing more greenfield sooner, essentially.
So when you say 30 years of growth, would that be inclusive of greenfield, urban zoning and future development areas combined? Or
Yes, that's correct. The proposed plan does have some of that medium density which may or may not be fully realised, but then it also has some limited greenfield, but the 30 years, years 11 onwards has significant areas of greenfield set out in the spatial plan.
That's currently identified as future urban growth area or FTA or F.
Yeah, some of it is, yeah.
Yeah, okay, thank you.
Councillor Hopkins.
Thank you, Mr. Chair. Mr. Campbell, just looking at specific comments in relation to this spatial plan you've mentioned, I notice on the bottom of page 2, there's a note, we can and should review the Oamaru Western and Kakanui spatial plan once reform is implemented. I'm curious to know, I mean, I'm looking at what has been proposed in the reforms and looking at your summary of the government's policy releases, although I'm more than somewhat surprised that you've actually failed to include the prime driver of the changes, which is a greater emphasis on and protection of private property rights, which the government has repeatedly reiterated as its foremost intention with regard to the reforms it's proposing. But parking that for the moment, I'm just curious to know how significant a review of the Oamaru Western and Kakanui spatial plan might be required. Equally, looking at the implications for the new spatial plan that you've talked about, are you saying that we would need to have a special zone for the Pukeuri freezing works? I know the Macraes mine has its own zone at the moment. And also the bullet point above that references statutory acknowledgements from treaty settlements and SASMs to be included. I can see how statutory acknowledgements for treaty settlements might be included, but I can't see how SASM ones, because the only references to SASMs specifically that I'm aware of are those that exist in district plans.
Yeah, thank you, Councillor Hopkins. So going back to the first question around the spatial plan, so I mean, we can review it at any stage. It's just really a matter of capacity in terms of how things are tracking in terms of growth for the Oamaru Western Kakanui. We would look at building consents issued. The report we provide to council every year kind of tracks that commercial and residential land development and rents, that sort of thing. So it picks up some of those factors that are basically the supply side of it, but also demand in terms of rents and so on. So that comes through in our annual report anyway to council. It's what we do with that data to align it with where's the housing going. Is it all happening up the valley versus is it happening around Oamaru Western, that type of thing. I guess once we know what constraints may be released, for example, the LUC3, that would then say, well, we can review it in light of some of that land could be used for future urban growth. A quick comment on the property rights. At this stage, there's nothing in the national direction that addresses private property rights that I think will come through in phase 3. So there's nothing here that specifically covers that, other than some of the loosening of restrictions.
Well, the intention's been repeatedly and very clearly signalled.
Councillor Hopkins, can you let Mr. Campbell finish his reply, please?
Yeah, I totally acknowledge that. I'm just saying that in this suite of changes coming through on national direction, there's no kind of direct mention of private property rights, but I think that will be in the phase 3 reform. So it's coming, I think. Yeah. In terms of the spatial plan under the Planning Act, there's two things that are signalled. One is obviously the treaty settlement statutory acknowledgement areas, which are already known, and they have signalled that those kind of cultural values will be picked up through that sort of regional scale mapping of SASMs. We know that Ngāi Tahu has basically done that for most of the South Island, so they'll look to kind of import that across into regional spatial plans. And if there's any, I guess, tweaks to that have been made at a district level, they'll use those to inform the regional spatial plan, because that's kind of what's agreed at a lower level, is my understanding.
No further questions? Oh,
Well, just, so this regional spatial plan that you've just referenced, will that preempt and or replace the existing, relatively small scale and localised spatial plans that councils like ours may have in particular areas like Oamaru, Western and Kakanui? If there's going to be a regional spatial plan, wouldn't any subordinate plans of that nature be incorporated within it rather than stand separate from it?
Yes, that's correct. Probably didn't explain that well enough at the bottom of page 2. So where it's prepared, a spatial plan is prepared under Local Government Act, as we have done, it's deemed to be a spatial plan under the new Act. And that would, we're not going to revisit that and redo it as from scratch, but it would be incorporated in the regional plan, and we're entitled to keep reviewing it anyway to say, is it up to date, other things that need to be adjusted. So yes, they would pull in those. They're not seeking a whole lot of rework or starting from scratch in that respect. Particularly, you look at Greater Christchurch, there's some, a lot of spatial planning has been done there that they wouldn't reinvent that, for instance, be huge. But yeah, trying to pull in the ones that have already done it, but there might be some gaps around the region that need addressing. Yeah.
all right, thank you for that. If you'd like to proceed with the presentation around options for the plan, Mr. Campbell.
Thank you. Yeah, so we've set out sort of some advice there on each of the 3 options asked for by the subcommittee at the April meeting. And it largely speaks to the, I guess, the legislation we're working with. So it's probably a good sort of segue into introducing Anderson Lloyd to run through kind of the summary of the advice provided as part of that. So Arlene's got it up on screen now for us.
Just before we go there, bearing in mind that we've had this material for some time, but there were people in the room and potentially online who aren't or may not be. The 3 questions or the 3 options that we asked for a report on was progression of the plan as it stands, a modified plan by way of parking some chapters, potentially controversial or however you want to say it, or parking the whole plan. So that was the advice that we sought. So just so people understand that there's 3 parts to the question.
Yeah, thank you, Mr. Chair. I should have mentioned that. It is in the paper there on that, the start, what those sort of 3 questions were. And yeah, we've sought to go through each of those, the options there for those. So I'll hand over to Shelley and Michael for that.
Michael, sorry to interrupt before you start, but welcome to you and Shelley. As I pointed out earlier, my legal career finished before it ever started. But just for clarity, in the planning space, we talk about a hierarchy of planning documents that we work to. Does that same hierarchy apply in the legal space in terms of decisions of various levels of the legal system?
Well, good morning, councillors, officers and members of the public. Michael Garvett's my name. I'm with Shelley Chadwick. We specialise in resource management law, and we're from Anderson Lloyd. So good morning. Just to answer your question, Mr. Chair, yes, absolutely. There is a strict hierarchy of authority through the legal system, from Parliament to the superior courts right through, and each is binding on the subsequent or subordinate decision making. So absolutely.
Thank you for that.
Yeah, no problem. So we've been tasked with providing you advice, which we have done in writing, which you've had available to you. And what I intended to do is to pick the eyes out of that and give you an overview of that with the PowerPoint that Arlene can run through with me. And we're obviously available to answer questions or discuss any of those. So Arlene, if we go to the first slide, thank you. We've obviously focused on the three issues that the subcommittee have asked for advice on, being when we've ordered them in terms of pausing the plan, partial withdrawal, or just to continue as it is. So I'll go through each of those now.
Apologies, it's frozen. I'll get it working.
Ah, brilliant.
I think everyone spoke too long.
I will just remind members of the subcommittee that the same rules apply. Questions will come at the end of the presentation so that Michael and Shelley can give us all the information we need.
Just to put your minds at rest, my overview should only be a quarter of an hour or so. So we're not going to use up all your energy. We won't use all your energy. So the first of the options in terms of pausing the district plan, we've just framed up for each of these how in our assessment you would go about implementing each of these options. So we've explained that in the paper and we've identified the legal risks and implications for you. So the first option being to pause, we consider that would be a decision under the Local Government Act. There's no such actual section or provision in the Resource Management Act to pause a plan. There are prescribed steps that follow one after the other. And once you commence a district plan review, then it's prescribed what the next step is and so on and so forth. It doesn't actually provide statutory authority or provision or process for pausing. So it's our assessment that pausing the plan is a decision that you would make under the Local Government Act as elected members to effectively instruct staff to stop processing the plan, and that would be a direction of council. We consider under your normal assessment of significance, that would be a significant decision. There are a lot of people with an interest in the provisions and outcomes of the plan. You know, classic examples are developers who may well be looking to take advantage of new zones and so on. So there would be interest. It's a new proposal and it's our assessment it would be a significant decision, and it would be our recommendation you're really duty bound to consult and go out and seek feedback from your constituents about what they think about that decision and take that on board before you make a decision to instruct staff to pause the processing. The next option to partially withdraw the district plan is a different decision. We assess it is a regulatory decision to be made under the Resource Management Act. There is a section in the Act that authorises the council to withdraw all or part of the district plan. So it is an available statutory decision to the council. It's our assessment and advice that it ought to be made based on evidence and it ought to be a principled one based on advancing the purpose of the RMA, because if you're scrutinised in that decision making, that is the sort of evidence base and reasons and justification that the courts would be looking to understand as to why you've withdrawn parts of the district plan and not others, and how that advances the purpose of the RMA. So it can be done. Again, we consider that those with an interest in that decision should be consulted as a matter of good practice and procedural protection. And without doing that, I'll go through and highlight in a moment a case where the court did invalidate such a decision without consultation. So it's an important thing to be aware of. And the third option is to continue. And in our advice, we've categorised that as the default or the regular steps, the Act once you've commenced as council has done the review of the district plan. You've notified that to the community, and all members of the community have had the opportunity to submit. The expectation under the Act is that those submitters are entitled to present to a decision maker, have their submissions and evidence considered and decisions made, leading ultimately to the adoption of a new current fit for purpose plan. So that's conventional. We have no concerns legally with that. That's the tried and true path that we ought to go down unless council intervene and take one of the other steps. So Eileen, I'll just dive into some of the slightly more detail on each of those options. So in terms of pausing, we understand the proposition is that the council be asked to pause for 6 months. It's our assessment that add 6 months to today, so we're talking Christmas, early in the new year, probably in our assessment, nothing much is going to be different to what you're dealing with today. The government will be on their program, as you've heard from Mr. Campbell, landing national direction. They are indicating that by the end of this year, they will notify a new statute for public consultation, the usual statutory process, and their intention is to land that by middle of next year, well before the election. And that then, if it is landed in the form that they've sort of publicised and touted, then there'll be quite some rollout over many, many years to implement it in the way that Mr. Campbell's outlined to you. So what that means in a legal sense between now and say 6 months down the track, nothing much is going to change structurally in terms of the RMA. The point Mr. Campbell made is one I'll just underline to you and highlight, that the advice from the ministry is that there will be transitional provisions, which mean that your current plan, which is notified and progressing under the current RMA, continues under the RMA till its conclusion. So again, that's another reason, if you are continuing with the district plan in whole or in part, it does continue under the current statutory settings. And that's a critical point because they aren't going to change for the duration of this district plan's development. So it's hard for us to see any upside in a 6-month pause. We're not seeing particular legislative or major change that we obviously say, yes, it would be hugely advantageous to await that and then everything will change. It's not going to be like that. There will be, for the longer the plans are in a state of flux, we're operating under the old current operative plan and the proposed plan. And so we just make the point that the longer that period of transition continues, the more complexity there is in the system and the more friction and cost and complexity for officers to administer the plan and those out there in the community trying to comply with it. So it does extend the period of that. Further delays just really delay the date on which the plan decisions are made and locking in the new zones and new provisions and the potential opportunity for people to avail themselves of operative plans and operative rules, and dispense with the old plan. So it just perpetuates that time of uncertainty. One of the important legal consequences of pausing that I do need to make sure you're aware of is that there is a statutory period of 2 years from notification to get the decisions out on submissions. That's a statutory deadline, and the Act provides that if you don't meet that, you need ministerial dispensation or an extension. So the officers have programmed the decision making to get them made and landed within that 2-year window. And we highlight that should you not achieve that, you will need to apply to the Minister for an extension. We have recently done that for Timaru because they were working hard and they were going to not meet the deadline, and the ministry advice and the Minister wanted a reasonable amount of explanation as to what you're doing to achieve it, why you're not going to meet the deadline, what your new deadline is and what steps you'll have in place to achieve, compliance, as soon as you can. So I'm not saying you won't get permission, but what I am saying is you would need permission if you go over that deadline, and you're in the hands of the minister and they are expecting a degree of rigour around why you haven't met it and what you're going to do to comply. So it is important to note that a delay will push you outside that. You will be then in the hands of the minister in terms of seeking and obtaining dispensation. So that for us is a key legal backstop that the Act currently has that is important to be aware of with a pause option. The only other legal implication which we are aware of, and it's to draw to your attention, is that the current statute, the RMA, requires every 10 years for the council to notify the plan, get it out there, allow people to submit, bring it up to date, and bring in national direction as it is at the time you do your review, which the staff are all working through. By pausing that, it just defers implementing the new national direction that's currently in play, and it just defers and I suppose delays the opportunity for submitters to get those decisions made on their submission. So there is some risk of people taking exception to a pause and possibly challenging that. You can never make a risk-free decision, but those are the elements of the legal way in which you'd go about it, and some of the implications. So that's probably what I wanted to say about pause. If I move next to the possible option of a partial withdrawal. Thank you, Eileen. One of the key, and it's not so much a legal, it's more a practical and operational issue about where the clean break would be in the plan. The plan is obviously designed and developed as an integrated whole with cross connections and interrelationships and so on and so forth. The rural zone provisions will rely on the overlays, and provisions are interconnected. And so it isn't, when you're thinking about a partial withdrawal, the obvious issue is withdrawal of what, and what are the implications for the integrity of the operation of the plan. Can it stand alone and can it function appropriately and properly without causing gaps and dead ends in it where there's elements are withdrawn? So that is a key issue. A withdrawal, the power to withdraw is simply that you can pull bits out. You can't make consequential changes or add bits in or make fixes with a withdrawal. So it is a matter of ring fencing particular identified provisions, withdrawing them out and they disappear, and the rest remains. So that's an important concept to be aware of with a withdrawal. If there was a need to make consequential changes or alterations to effect a withdrawal, you have to then commence a variation to the plan, which is a whole new notified variation, which then would have to be done to mop up any sort of implications from a withdrawal. So that kicks into a new statutory process if there are tidy ups that would be needed to actually implement a withdrawal. So that's a real practical problem that would need to be thought about quite carefully about where that clean break sits. As I said in opening, a withdrawal is done under the RMA. We consider it should be evidence-based, so you should get planning advice on what the reason for withdrawing provisions are and how that is consistent with the RMA. I've already made the point that the Act currently requires review every 10 years, and that's what you're doing. You're following that statutory process. The Act does have provisions about doing things as reasonably practicable and delivering in a timely manner and so on. You'd need to just be aware of that and satisfy yourselves that you are still acting in a timely way in any decision that council would eventually make on this issue. We highlight with this issue, this option, this is probably the greatest risk of challenge. As I've said, there are quite a few areas where an inventive lawyer can challenge council on this option for a variety of the reasons that I've highlighted. This is probably the highest risk legal option. And there's a risk that someone could take proceedings in the Environment Court seeking a declaration that you've acted in some way inconsistently with the RMA as it currently is, or the High Court, or worse, both. And so that's a contingent risk that sits out there that you can't really mitigate other than in the ways that I've talked about, to have an evidence-based decision, good reasons, preferably consult with the community so that the procedural elements of a decision are ticked off and addressed, and council makes the decision ultimately in light of all that information to protect your procedures. But ultimately someone could take issue with the decision of withdrawing part of a plan when it's partway through the process. So that is a potential legal risk. It's very difficult to quantify whether anyone ever would or what they would challenge and how determined they are. But that is an issue that sits out there. Okay, Elaine. The continuation, as I simply say, that's conventional. That's just consistent with the current provisions in the Act, and you'd be meeting your procedural expectations that are currently in the statute. And staff have programmed the decisions on submissions so that they are delivered within that 2-year window I talked about earlier. So we don't see that as increasing or creating legal risk. It's conventional, it's normal. There are a range of probably benefits that we've outlined in the paper that I'll just simply rattle through. One of them, and it picks up on the point Mr. Campbell made, there is a raft of government guidance and national policy coming through this year. And they're certainly indicating that they plan to land that this year. The state of the district plan process is that where decisions are to be made by the hearing panel, they can take into account, and they actually are required to take into account, current national direction as it is on the date that they make the decisions. So to the extent submissions allow, the panel can feed new national direction into objectives, policies and rules in your current plan as they go through the hearing and decision-making process. So we see it as the timing of your process at the moment is reasonably advantageous to feed in current national direction as it lands, and try and incorporate it where you can in the decisions of the current process. So that is actually advantageous for this council. The normal process, once national direction comes out, then you have to notify and prepare a variation or a plan change to implement the new national direction. So we see where you can feed it in through your current process, it's probably quite cost effective and efficient to actually feed that in. So that is something we think is quite desirable. The other advantage is probably one Mr. Campbell's already highlighted, that as you go in next year to a regional planning exercise, assuming the government do land their legislation and it rolls out, it would be desirable for this council to have an up-to-date version of a plan with current provisions that then you can advocate to the regional organisation to pick up and adopt and feed into the regional policies and plans. So to the extent that's seen as advantageous, we can certainly see that being desirable and a good basis to go into those regional planning exercises. the last one's not so much legal, but you're running a regulatory process at the moment, which you've budgeted for, and my greater concern is to meet those statutory 2-year deadlines. It's, I suppose this is business as usual, and it's almost risk-free from a legal point of view, and it's budgeted. So that's our sort of overview of the continuation. It's status quo really. And I think, Arlene, is there another slide? Yeah, no, that was all we wanted to specifically highlight. There's probably nothing particularly new from what we wrote in the paper, but very happy to take or answer questions or discuss any of that councillors have. Thank you. Yes.
Thank you, Michael. I note in the material that we were supplied, some of your argument was based on the decision of Aldermas Investments versus the Gisborne District Council. Surprisingly, last night we received information from parties engaged in this district plan, namely the Waitaki Guardians, who I understand represent in excess of 200 landholders. And that opinion says that that particular case was overruled by a superior court when the West Coast Regional Council was challenged and that Aldermas was overruled.
Yeah, so there's what you're saying is that a different outcome was reached in the West Coast. There's been various decisions where councils have withdrawn provisions, but I'm not aware of the Gisborne District Council decision going to the High Court and being overruled. So my understanding is that that decision is binding on the Gisborne District Council. There was probably a different decision made by a different division of the Environment Court on the West Coast, which isn't necessarily binding on Gisborne. But
No, it was a decision made by the High Court that specifically disagreed with the findings of Shepherd J in the Aldermas, that a public notification process, including an opportunity for parties to make submissions, and an appeal was required before local authority could seek to withdraw part of a proposed plan.
right, yep.
So look, it doesn't surprise me that legal practitioners have a different view of legislation, but we do. This committee is part of the Waitaki District Council, and we have an obligation to represent and support the desires of the community. So we have the Guardians Group, as I say, operating on behalf of 200 plus participants in the plan, saying that they would welcome a pause in the plan. I'm not saying I agree or disagree with that position. I need as much information as possible. So, Councillor Blackfoot, I'll go to you first.
Thank you. Thanks for the presentation. You mentioned at the end there that you saw it as advantageous to progress and feed in current national direction as part of the process as it falls, as is currently the path being taken. I just wondered on that basis then, how is a pause not more advantageous, given that you acknowledge that some of that work is actually still in train at the moment, and I do accept your point that there are other members of the community that do see it as advantageous to keep the plan progressing for reasons unrelated to these more contentious chapters. So, because I mean, you also talked about advancing the purpose of the RMA. Well, surely we need to be thinking about advancing the purpose of the new RMA, or as you've labelled it, at the same time.
Yes, I do agree with you that if there was a pause, then when the plan is picked up and recommenced, absolutely the same point would apply, that whatever national direction is in play there could be fed into the process. I agree fully with you that factor would apply to a pause or continuing. Yep.
And around I guess my problem is we don't, you know, the new RMA as you've labelled it in the presentation, we don't precisely know what that looks like yet. So how then can you seek to incorporate that into decision making?
What I was talking about incorporating in the decision is national direction, being new policy statements or new national standards that get issued by government. So that in the paper, David's listed quite a raft of them that are coming this year. They are different from the new legislation. So the government are currently issuing a raft of new national guidance under the current RMA, and they're intending to essentially have that operative certainly this year, they're saying. So a lot of it's out for consultation, as you've heard, due back in August, for them to pick up and issue new national direction later this year. So that, assuming they do that, then that national direction comes out, it's issued under the current RMA, and the duty is to then implement it by council. And so, as you've rightly said, if you pause, then when the hearings resume, they could pick up and address some of that, or just address it as they go. That's quite different from the new RMA, which they are saying that they're going to scrap the current RMA and introduce whole new legislation, sort of operative middle of next year. And what I was trying to explain is that your current plan is going to be dealt with under the current RMA, not the new RMA.
Even if we pause.
Yep, because that's the point with that transitional provision, that because your plan is prepared, notified, developed, it would be heard and considered under the current RMA.
Sorry, can you just clarify who that ruling's been made by? Apologies if I wasn't listening.
Yeah, no problem. So the law as it currently is, the Resource Management Act as we know it, sets all the provisions for developing and dealing with the plan as it currently is. So your plan has been developed under that, and it is progressing under that. The new legislation is planning to scrap the current RMA and create a new act. And as David has said, which is our understanding, that the ministry is saying there will be transitional provisions in the new act, which means that it will say something like, but we don't have it, but they're saying there will be transitional provisions that current planning processes that are commenced under the current Resource Management Act continue and get concluded under the Act as we know it today. And that is almost invariably what happens in any legislation, that processes that are commenced and continuing under prior legislation get concluded under the old legislation. So that sounds conventional. It's what the ministry are advising officers, and it's what we would actually expect. Does that help?
Yeah. Sorry, Shelley.
Can I just add, in terms of the new legislation timeframes, and it has to be spitballing because we don't know. But the indications given by the government are that the legislation will be put out for a select committee and process this year. That will take at least 6 months, and then the goal is for the government to have that new legislation enacted before the election. It's a big ask because it's a massive piece of legislation, so it might end up having to be staged. We don't know. So working on the basis the new legislation comes out before the next election, that is mid-2026, maybe even a couple months after that. The transitional period in new legislation has to be provided for because we all need predictability about our operations. And if legislation is changing how things are going to run, it needs to provide for a period of time for everyone to adjust to the new normal. The new normal in the new legislation is potentially quite extensive. So therefore, I would usually expect with a large amount of change, you would have a longer transition period. But again, spitballing, if it was an urgent transition period, I would probably see that more in the nature of 2 to 5 years for something as big as functions to transfer from district to regional council, for something as big as district plans being shifted into a regional one plan approach. That transition period's potentially, I mean, it might be 1 year, but staff are going to be running very fast to be able to cope with a 1 year transition period. So just to put the new legislation, which is something that we see coming and we know it's going to change things in a time scale, that's what we need to appreciate for the thoughts that you're having about how to accommodate that. And I totally acknowledge it's very difficult for council because we can see it coming. This is critical work for council and it's high profile. So it's challenging to find the best way through and the most economical way through in terms of your regulatory role. So does that assist in terms of trying to see where things are coming?
We'll go to Mr. Campbell.
Yeah, just a couple of other points. Picking up on Councillor Blackler's question. So going back to the scenario I talked about earlier with like Waimate and Ashburton that haven't commenced a review, if they don't commence a review, they then would be tied into this new process of a regional plan and the spatial planning. So they get involved there and rely on that to essentially update their old district plans. What it means is in the transition, their old plans would come across to the regional plan. If Timaru Mackenzie us have newer plans, then they would slide across those newer plans into that regional model. The other point, just going back to the national direction, and on page 3, there's most of those are set out there. There's also the housing one that's just come through, but a lot of these are existing. So the ones around electricity, telecoms, forestry, highly productive land. So there'll be adjustments to those. Likes of the forestry one, often they kind of trump district plans anyway. So there's cases where no changes to a district plan are needed. So some of those are kind of standalone plan, yes, standards or policies. Others may require changes to the district plan. For instance, if the highly productive land decides that, if the government decides that LUC3 is out, then it's a change to your mapping essentially to scrub that out. And they may not require a whole variation process. They may just say, look, do it. Because as they're saying nationally, there's no need for it. So there's no point having a variation that people are going to challenge when it's clear what they want to do. So some of those, as Mr. Garbutt said, might require a variation, but we expect some of them will just be standalone and the plan just has to align with them going forward.
So can I just, while you've got the microphone, David, because something that we've discussed previously is proceeding by way of a pause, in the sense that the contentious chapters could be left to the last of the hearings or the processing. Can you elucidate on that a bit further?
Yeah, I mean, certainly where you've got less submissions on certain chapters, you could progress them through hearings. And it's all down to timing with the hearings panel, but you might decide where there's contentious issues. Let's see where some of this, particularly the phase 3, might land. And it might mean that the panel might have a different sort of view on how to deal with it at that time, rather than having to necessarily rush through and make decisions on those submissions. But we'll welcome your thoughts on that.
I'd agree that national direction is most likely to take effect if the hearings for the more contentious chapters are at the end of the process. So if hearings start November, December, and then they run for 6 to 12 months. So say that would take you to halfway through 2026. And I think that we are confident the national direction is going to take effect. The national direction being consulted on now, and the housing growth provisions as well, they will take effect before mid-2026. So I think you can have confidence that anything in there will be able to be taken account of by the panel if those hearings are happening then. So it does a little bit depend on when the hearings happen, but there's also usually a mop-up hearing when you might then give parties the opportunity to pick up anything that's changed in terms of national direction right at the end of the hearing process. So then the parties can come along and have one more say if something's shifted. And in terms of phase 3, which is the new legislation which might be being consulted on, certainly every party has the opportunity to bring information and comments in respect of anything that's happening at the time to the hearing they're interested in. So if they want to address the panel and provide a position for the panel to consider based on that new legislation at that time, that can happen as well.
Thank you. I'm coming to you, Councillor Hopkins, but I've got Mayor Kircher first.
Thank you, Mr. Chair. Morning, Michael and Shelley, and members of the public who are here as well. First of all, declaration, I've made a submission to the plan on the basis that I won't be part of council and won't be part of the decision making when that time comes. So just acknowledge that. What I wanted to say is thank you for acknowledging this is a very difficult situation for our council to be in, and not one that we really like to be in. Equally, it's a position that our community is in, and we don't want them to be in that, and we really are stuck between a rock and a hard place on this. We've got the minister coming out just as recently as yesterday saying they're prepared to take powers off council and override decisions. Equally, we've got them saying we're going to be postponing, we're going to be changing the rules, but they haven't changed them yet. So we have that contradiction, and we have our community going to a lot of cost. We're going to a lot of cost. So, and I'm sure you understand our position with that. Part of me wants to suggest that we write to the minister and say, this is where you've got us. What are they going to do to actually help us? They need to find the solution, because we're stuck in the middle, and if we don't progress one part of the plan, we're going to be in trouble. If we do progress the other part of the plan, we'll be in trouble. So do you have any thoughts on that? You know, not just seeking dispensation from the minister to delay the process at that 2-year period that you talked about, Michael. Yeah, what are your thoughts?
Yes, I do have some thoughts on that. And it stems from our experience. We've recently been through a very similar exercise to this in Mackenzie District, and there's no problem writing to the minister. They did do that. They wrote to the minister, and this was about 4 months ago. They were going through this exercise, and Mayor wrote to the minister and said, you're putting us in a terrible position. We were partway through the hearing process at that point, and they were generating quite a lot of antagonism in the community about why are we carrying on with this when the government say they're about to scrap the whole thing. And on the public record and the public agendas for their meetings on this, so it's not breaching any privacy or anything, the minister did write back, and the advice from the ministry and the Minister for the Environment was that the current RMA hasn't suspended anything. You should continue with your current statutory planning as you normally would. And so they received advice to that effect, and it would be, we could provide it to David, it's on the public record. So they were left with to make up their own minds, basically. The government are certainly active in the press and saying what they will be doing, absolutely. And the industry is in a very difficult position of flux and uncertainty. But all I can relay is what the Minister has said to Mackenzie, which does align with our legal advice that, as I've said to you already this morning, the law you're acting under currently is what we've outlined, and that's probably not going to change until at least the middle of next year, with, as Shelley has outlined to you, quite a long rollout after that. So that's the best advice I can give you. I think ultimately it comes back to the council table to decide, in light of all that uncertainty, what is the best thing to do for this district.
one other question, is more for Roger or David, probably. Have officers made any submissions to the plan at this stage?
Thank you, Mayor Kuchar. The staff submission signed off by council has been lodged, but I'm not aware of officers in the planning team making individual submissions. So
I meant official ones, other than the one that we are aware of.
no, I'm not aware. I'm aware that ex-staff of council have made submissions.
Councillor Hopkins.
Thank you, Mr. Chair. I've got a couple of questions for Michael in a moment, but if I could just follow up on the point you made before about the timetabling of controversial chapters. And I'm wondering if David, Michael, Shelley, you would agree that such timetabling has the potential to be a de facto plan pause and or withdrawal of certain contentious chapters. I mean, in effect, is that timetabling subject to the timetable? Is it in effect a de facto pause? You know, is it the pause you have when you're not having a pause?
I actually don't think it is. I think every district plan hearing panel has to schedule their work plan, and there's nothing wrong with scheduling topics in the manner that they see fit. So
But
the effect is you could defer.
I mean, there are certain environment court matters that are enacted now that won't, or timetabling the chapters won't affect that. But in terms of any capacity we might have to amend those chapters, what you basically said before was the longer you wait, the better, the more likely you are to be able to do that.
Councillor Hopkins, can I just remind you that it would be better to let us receive the answer first before you interject. Please consider yourself reprimanded.
No problem. Yes, so as long as the hearing schedule is programmed within that 2-year window, I have no concerns at all. And if there are chapters or topics that would benefit from time to let the national direction land and then be looked at in light of that, and you can accommodate that within the statutory scheduling, that seems a perfectly rational and appropriate decision to make, and one we wouldn't criticise or question at all. It makes good sense. Yeah. The only rider would be that it's probably for the panel to determine, because they're looking at drawing on, they normally do it in a orderly way, like strategic directions, and then, but there is flexibility once you get through certain topics to juggle. So that is something that can be looked at.
No, I just.
Yeah.
If I supplementary then to that, perhaps to you, David, or Mr. Campbell, would it be possible for either this committee to recommend to council or for the council to adopt a timetable that specified when certain chapters would be considered and would indicate that they would not be considered earlier than that?
It's certainly open to the committee and the council, but in my experience, it would probably be most beneficial as a recommendation. And the reason I say that is once delegations are made to the hearing panel, it is for the hearing panel to then conduct their hearings as they see fit and make directions as to process that is in accordance with how they wish to conduct their hearings. There is a interaction between council and its hearing panel, which can be more or less in terms of how much interaction there is, but that's probably where I would suggest it sit as a recommendation. My previous experience this year with a full plan process, review process, is that some of the chapters which I understand to be contentious in this district were actually the ones we came to at the end of that process. So whether or not the panel that Waitaki engages follows a similar process, I think it is relatively standard. I think, as you observe, potentially some of these chapters are probably going to come at the end anyway.
I'm sorry, I'll just let councillor Blackler and then I'll come back to you.
Was it a follow-up?
Sorry?
Are you sure? Was it a follow-up?
No, it's a new question.
Thank you. Yeah, I just wanted to drill into a little bit more into like understanding the genuine scope, professionally and administratively in the process to amend and incorporate new national direction if we do continue. Because I feel like we need to have a good level of confidence that, this will be able to actually genuinely occur. And we've discussed the strategic placement of various topics in the hearings, but if you think about the development and use of Section 42A reports, which require a lot of steps and a lot of work in advance of actually getting to the hearings point. I suppose even to a degree, like the expert caucusing and stuff like that can occur at various steps. Like, is there a risk that even with the strategic placement of those later down the track of the hearings, that it still might not fall, the timing might not fall right in terms of the expert that's providing the advice to the hearings panel incorporating new direction?
Probably a difficult question to give a specific and clear answer on, in the sense that the constraints that you're wrestling with, there needs to be submissions raising a topic, firstly, for there to be changes to the notified plan. So we're always governed to an extent by what people have submitted on. We know there's quite wide submissions, so that's probably going to be okay with your plan. And then, yes, there's timing of when national direction lands, but it sounds as though we're going to get most of it about September, October, November, depending on how fast the government move. So most of it will be in effect before next year, say. So a lot of it can be taken into account as officers prepare their 42A reports and people prepare evidence and hearing panel make their deliberation. So timing wise should be okay on your current track. And as Councillor Hopkins has alluded, if there are more challenging topics further back into next year, then it will have absolutely landed and you won't, it can be taken into account there. So those are sort of the constraints. Yeah, that's probably the best answer I can give.
There is an obligation in the Act for decision makers to take account of national direction, and that is across the board. So I mentioned the mop-up opportunity. I think that any decision-making panel would be highly likely to be seeking further advice if new national direction came into effect during the hearings process, but before decisions were made. And they would ask for the parties involved in that topic to come and address them on that. So I don't think there's really any lenience in terms of obligations to have to take into account.
Sorry, just one further point that's occurred to me that is probably important to raise on that topic is that your question is striving for when is going to be the time where the national framework and all the relevant information is certain. And in my 28 years in this industry, it has never been achieved yet. And I don't think it will be anytime soon, because as soon as the government introduce national direction, like Mr. Campbell's outlined, there's always an argument, oh, we need to wait on the regional council to put it in their regional policy statement. That's a 5-year exercise. We can't do anything until that happens, and then we should act. And so there is always a high degree of uncertainty, particularly where national level government start rolling out guidance. And all we're saying is, in the process that you're in, there's the opportunity to feed it in where you reasonably can, but probably it's illusory to think it's ever completely settled and certain. Yep.
We'll just let Mr. Campbell comment as well before I come back to you, Councillor Buckler.
Just further to that, when we're working through some of the changes proposed in this national direction, we are looking at it and referring back to what's in the proposed plan. So for instance, I've been looking at the NPS on renewable electricity generation, and a lot of what we've got in the plan aligns fairly closely with what's being changed. There are some minor tweaks that we'd probably have to do, but I think you could probably take some comfort that some of the changes come through. We've kind of been a bit more forward thinking in our proposed plan, trying to provide for some of those things a bit more proactively, because there was a void nationally or regionally anyway. Also, you know, the Papakāinga, things like that. Obviously the commercial forestry kind of waxes and wanes depending on that, what's happening in that industry, but we've got provisions in there for carbon forestry, for instance, now in our proposed plan. So I think some of it will go back and go, well, there's probably not too much of a tweak to do. It generally will align in some places with it. Other areas, maybe not so much, but that's probably an advantage we've got, as we have actually kind of been a bit more proactive in some of those areas, not saying all of them, but that will help, I guess, at that hearing stage go, okay, well, plan's pretty close to this anyway. It might be tweaked a wee bit to align.
Mr. Cook?
Thank you, Mr. Chair. I wonder if it may be beneficial if Mr. Campbell was just able to give us a little bit of an indicative timeframe of where he's got to with the collation of the current submissions, and the timeframe if we do continue, what that looks like, because we're probably going to be towards the end of the year anyway.
Yeah, thanks. So as I mentioned at the start, we've got just over 300. We've working through a lot of the more straightforward ones. Obviously, when we get into the larger submissions, some of them raise over 100 submission points. That takes time to get entered and summarised. We'll probably get some extra help to help speed that up. And with a view to trying to get through them sort of by the end of winter, start of spring. So it's ready to go out as a summary of submissions for further submissions. But we're not giving an exact date. It's until you get into those sort of big meaty ones, you're not really sure how long it's going to take, but we will resource up to keep it moving.
Just as illustration, are you able to refer to the information you gave me about Gore and the number of submissions and number of submission points they got, and then the time frame for submissions on submissions?
Yeah, so we were talking to planning colleagues at Gore that they had 130 submissions. It generated over 5,000 submission points. So someone might ask for multiple things. That took a team of at least 4 staff over a month to summarise. So we've got over double that in terms of submissions. We haven't got that many staff.
Mr. Chair, just quickly on that, is the use of AI considered for helping to summarise that, because it can do a lot of the heavy lifting?
Sure is.
Councillor Hopkins.
Thank you. Michael, just a couple of, Mr. Garbutt, I should say, just a couple of questions with regard to the options you gave us. First of all, with regard to withdrawal of certain contentious chapters, your advice to us was that the Elder Moss decision signalled that in the Gisborne case, the withdrawal was ultra vires because the public consultation had not taken place. The High Court ruling subsequently made in reference to the High Court consideration of the Forest and Bird and West Coast Regional Council case later, so it is subsequent, actually ruled in paragraphs 66, 67, 70, 75, 76 and 77 that such a consultation at point of withdrawal or prior to withdrawal was not necessary. If, having looked at that, you were satisfied that that indeed was a superior argument subsequent to the earlier consideration, and therefore, if you like, the one that stands at the moment, would you accept that withdrawal would not necessarily require a public consultation prior to the act of withdrawal?
Yes, in the sense that what we said in our advice is that the Act doesn't set out any procedure or steps or requirements at all. So the Act is silent on this, and the Aldamos case in Gisborne said, they reflected that and said there is no procedure, and but what they determined there is, and they did say some withdrawals can be done just as a matter of resolution, no problem. So they recognise that too. But they did say where in that particular case there had been people relying on provisions for quite some time, that they did invalidate that withdrawal because they hadn't been consulted with. So we wanted you to be aware of that and to say, look, there is a risk if someone wants to tackle such a decision, they would challenge it on the basis that it's not consulted about. We think it's still prudent, particularly if you're going to do a wide-ranging withdrawal that has interests that are wide-ranging. I've certainly dealt with withdrawals of a particular rule that Gore did not too long ago, and Mackenzie considered withdrawal of one subpart of a rule, and Gore did consult, Mackenzie didn't, but they were very narrow provisions. If you're looking at withdrawal where there are quite wide-ranging rights and interests at stake, we think it would be prudent, if that were a proposition, to protect your procedures, to go out and seek views of those who might have an interest in that. To do, and I fully take the point, the Act doesn't require it, and the courts have recognised you don't always have to, but there is a case where they said in that case you should have. And so it does turn on the facts, and that's our advice, as I'm repeating myself. If it's wide-ranging and there are wide-ranging interests, it would be prudent to go out and seek the views before you make a decision.
Can I just add, my understanding is the Aldamus case went higher than the High Court. So at the moment it's still good law. So I would anticipate the High Court case from the West Coast was distinguished on the basis of its facts. So technical legal points, but the principles in Aldamus are still likely to be strong and able to be relied on by someone wishing to challenge council, and then we would get into a squabble between the two cases probably if that happened.
If I may, I've just two other questions. First of them, I'm wondering if you could clarify. You said with the presentation, the final option carrying on, you said that's going to be the easiest way to incorporate any new changes. Now, I'm sorry, I'll defer to your RMA case law experience in this regard, but I can't see any difference between incorporating changes in the plan currently or in a variation of the plan subsequent to withdrawal. I mean, as I understand it at the moment, the only issue, if we withdraw a chapter or chapters, it would be possible to continue consideration of any issues within the context of the chapter that had been raised in submissions. but anything outside the scope of the submissions would require a variation. Now, that simply says, this is the variation, here's our arguments for doing it, everyone submits. Now, that's effectively no different from the process that we have at the moment. So I can't, on the prima facie, see how there's a difference in the ease or fluidity with which changes could be incorporated through one process or the other.
The simple point in response to that is if you withdraw a chapter, it is gone. There can't be any changes. The submissions on that fall away and they're not considered. So if let's put an example around it. If you withdrew the rural chapter out of the plan, once it's withdrawn, it's gone. It's dead, and all the submissions on that chapter fall away and they're not considered. So that's the consequence of a withdrawal. It's gone forever. Yeah, to bring it back, council has to then bring a new variation or re-notify the plan again as a new starting point. Yeah, so that's the critical thing about a withdrawal, yeah. So I think you are wrestling with the idea if we withdraw it and someone submits for it to come back in, and that's not the case at all. Because council have the full authority, because it's your plan. Once it's withdrawn, it's off the table for the public. Exactly, yeah.
I appreciate the need for us to dive into the regulatory trough, so to speak, but I'm also conscious that there are landowners and ratepayers who are considerably stressed over this whole process, and I believe that as the elected representatives of our community, we have a responsibility to try and make this process as stressless as possible. And I think that we need to focus our decision-making on that. It may not be possible, but that really should be the aim, and it's certainly my aim, to try and get through this process in the most cost-effective and less stressful manner possible.
That's my question. See what options were most cost-effective and stress-free.
Councillor Blackler?
Yeah, I guess I just want to, continue exploring along the same lines of Councillor Hopkins. So, yeah, the topic of withdrawing or partially withdrawing chapters or clauses or whatever. I'm trying to reconcile that with your earlier comments about the need to advance the purpose of the RMA, which we've heard will need to continue as part of the transition process. So, like, let's say we sought to remove one of the sensitive overlay type chapters. How would the decision made by the local authority interact with because you talked about needing to show an explanation that kind of shows that you're keeping that at front of mind. So what would be a valid argument when you take into account the change in government direction set alongside that to progress such a move?
Yeah, so I can start with an answer on that. So the expectation for a evidence-based regulatory decision, which is what we're talking about with the withdrawal, would be that you would do what you would normally do with your planning and officers and say, give us some advice, what are the options, and we would expect some analysis of what are the benefits and costs and recommendations to council on should you withdraw this, and if so, how, and what are the consequences. The reason I say it should be evidence-based, so we would normally expect a decision like that at least some planner would say this is we've got this wrong. We'd recommend you withdraw it, or put this in its place, or fix it up, or do whatever, because that better achieves the regional policy or the national government policy or the Act itself, is really what I'm driving at. If you don't have any of that and the council just make a decision without any evidence and someone challenges it, then when we go to court, the first question the judge has is, where's the evidence? And present me the evidence, and the judge will analyse the evidence and make their own decision on the evidence. And so the elected member's decision is one aspect, but what I'm trying to burrow into is what would be the resource management justification that someone can turn up in a judicial court one day to explain to the judge, this is the basis for the decision and this is why it was made and these are the reasons. So that's what I'm trying to, if you were to head down that path, you want to put those steps in place.
Councillor Hopkins.
Yeah, just apropos, as a point of explanation, what I had thought might be the case was that effectively continuing with the notification process as currently mooted or intended, and a process under withdrawal of certain chapters was equivalent. What Mr. Garbutt has told us is that's not the case. And that one is slightly more problematic than the other, as I understand his answer. But I'm just curious, Michael, you said that, and I accept the point that if we were to withdraw chapters, there has to be RMA grounds for so doing. But I wonder if there are additional grounds as well. Specifically, might there be common law grounds where you have common law precepts that have RMA implications, i.e. the Queen's Chain and or law of trespass, whatever. And also, I'm wondering if there are LGA grounds, which again have RMA implications, but were there to be a challenge on the basis of process, would that in and of itself be a ground for withdrawing the plan? In other words, if it could be demonstrated that certain intentions, commitments had been made but had not been implemented, surely in law that would be a ground for withdrawal.
So the decision to withdraw is one made under the Resource Management Act, and as I've said, there's no specific process or criteria around it. And as the court has said, it should be principled and furthering the purpose of the RMA. I don't think common law comes into it. I think that's probably irrelevant in the sense of what you're referring to there, trespass, all those sorts of things, Queen's Chain. That doesn't really come into whether a provision that's currently been notified by this council in the district plan should now be withdrawn, because to do that deprives people of the opportunity to participate in the development of the plan. So a decision under the RMA to withdraw the plan should be based on RMA considerations. I think you could bring in cost because council has to fund, from an LGA point of view, fund and budget and work through the process, and so cost could be a relevant consideration. But bringing in extraneous or other things, I think, exposes you to greater levels of challenge and risk than focusing on RMA, which is where the decision is to be made.
But if, for the sake of argument, with respect to any given chapter, and I notice that there has been some legal argument provided to the Guardians that effectively all of our SNA classifications at the moment are ultra-vires because they place an undue reliance on the NPSIB and also a lack of, alleged lack of analytical process. But if you have a chapter or a provision that has Section 6 implications and impacts on the capacity of the plan to actually fully recognise, implement or enable or manage those section 6 application, issues, surely that would be, and if the oversight in relation to those objectives, policies and rules arose as a matter of process, surely that's a legitimate reason to advocate withdrawal.
I'm comfortable that's a perfectly relevant topic, absolutely. And you should say to staff, we've read that, that's concerning, is that true or not? Have we got this wrong or not? And council could exercise oversight over that. And if council decided, hey, we have got that horribly wrong for those reasons or other RMA reasons, you should know about that. I'm satisfied with that. Equally, those are the very matters that go to the hearing panel, and people are advocating their position. It's ultimately for the hearing panel to decide where the rights and wrongs of that are, or whether changes should be made. So I agree with you, that is a relevant thing. Council could exercise oversight as a governance body and say we want advice whether that is wrong or not, and we want to consider that. Or you leave that to run through the process, and the hearing panel will pick that issue up in light of whatever evidence and advice, and make a decision or adjust or cancel the provisions. Who knows?
Thank you, Michael.
Mr. Campbell?
Just another point further to that. Often where there's a procedural issue identified, the court will direct the council to correct it or, re-notify, do something. So the issue won't go away. It just says put it back in there in a different form or do a different process. So rather than sort of take something completely out, that they won't leave a void in the planning framework, essentially. Yeah.
Thank you.
If we were to remove, find grounds to remove it, through various considerations, any parts of a chapter or chapters, what would be there would be a variation down the track, but presumably that would be through the new regional function in due course. Is that how the process would kind of sit?
Just want to highlight one point from the report, I think, which is relevant to something what the issues that you're wrestling with, Councillor, and that's that there are some matters which are identified as matters of national importance, which it would be difficult to find a basis to not provide for in the district plan, and they just sit as slightly more important for council to address in its district plan. So those matters are noted in your papers. So in terms of finding a basis to withdraw certain chapters or certain provisions, probably would suggest that it's going to be very difficult to find a planning basis to do that, because these matters of national importance have been identified as sort of holding this higher priority. In terms of if provisions are withdrawn, the timing of the variation or any subsequent variation depends on the work that needs to be done by council in order to prepare the variation. So Mr. Campbell, if you think a small version of the notified proposed plan, that's what a variation would be. It requires staff to prepare the document, all of the supporting documents to be prepared as well, in terms of the evidence to demonstrate the thinking behind the proposed variation, and then it runs through a similar process in terms of notifications, submissions, and it may catch up to the proposed plan process, and then you hear them together. So in terms of timing, there's that work aspect, but there's also the council's decision about when to notify the proposed variation that affects timing as well.
And if such a decision was challenged, and what would be the likely outcome if it was found that our decision wasn't sound, we would just be instructed to reinsert it back in? Is that correct?
Is that the partial withdrawal?
Yeah.
Yes, so there's different ways that people can challenge it. They can challenge it potentially in the Environment Court, potentially in the High Court. I would probably see the High Court process that's coming out with a declaration. Declarations might tend to say that something was not correctly done. The High Court doesn't always make directions to councils to do something. They tend to decide whether or not they want to be that assertive. The Environment Court, on the other hand, if a process excuse me, was commenced in the Environment Court, it's much more likely you'd get a direction from the Environment Court to address any issues that they saw. And spitballing again, which seems to be my main job here today, but Environment Court and High Court processes are lengthy. So you're talking 6, 18 months, 2 years sometimes to get through that. So you're actually then having a process which is almost got 3 plans. You've got the current plan, you've got the proposed plan, and then you've got whatever the plan's going to be once the court process is finished. So in terms of uncertainty, it's almost worse than the legislative uncertainty that we're dealing with at the moment.
But if the removal of information from the plan was challenged, it would just be the principle of the removal, would it not? Not the content of the.
If we were running through an Environment Court process, there might be a situation where the Environment Court would come back with a requirement that council or say that council couldn't take a particular piece of, say, a provision that addressed national direction, and then somehow the court might find a way to say you have to go back to this point of the process, reinsert it and carry on. Would that be how you might see it running? It depends. There's so many variables depending on how it was challenged, who it was challenged by, what they asked the court to do. So it's almost too hard to really project that or answer that question.
Yeah, no, I accept that. Yeah, apologies.
We've got 15 minutes approximately left. Is there anything else around the table that wants to be raised? Because we've got a fair amount to digest from today's discussions, and I'm reminded of Councillor Hopkins' observation that the original author of the RMA was a lawyer, and probably as much as was motivated for the protection of the environment was also motivated by the protection of the legal profession and generating ongoing work for millennia to come. Mr. Campbell.
Just a further point, I think it was maybe mentioned in the report or the advice, is that now that we have 300 odd submitters, there is an expectation that they are in a process that will give them a chance to be heard and for their submission concerns to be dealt with. I guess delaying that kind of can create frustration for submitters. I mean, we've already had a first round with the draft plan, and people are coming back to try and get things resolved that haven't been necessarily fully resolved in that earlier process. So just be conscious that people have invested time and energy and effort into that, making submissions, and there is an expectation. People are already asking, when will the further submissions be out? When will hearings commence? So there's already that kind of level of interest by parties in the process. When's it going to, continue in terms of having a chance to have a say, get in front of the hearings panel and get decisions out kind of within that time frame. So I think that's an important consideration as a council looking after the community that have invested in this. They're expecting to continue in that process and have their say and deal with the outcomes that come out of it.
And on that point, if I add, my experience is that the issues that you're dealing with today are the issues that are also raised in front of the hearing panel. So it is another public forum for submitters to come along and wrestle with exactly the issues that you are turning over and ask the panel to address them in a specific way.
I think Councillor Blackford, did you have a question or? Well, just while you're thinking about it.
It was just,
All right.
it was
righto.
just a follow-up that I should have made, which was, we talked hypothetically about, you know, what might happen if a decision to withdraw is challenged. Could the hearings process for the balance of the chapters, would that continue unhindered if that process was in play? Until such time that naturally it couldn't, until a decision was reached.
I think that's probably realistic. Yes, it would depend a little bit on who the litigant is and how much you withdraw and how wide their challenge is. But I think that's probably right. The challenge would be about what's been withdrawn, and the rest is remaining live and should the expectation be it carry on. I just have in the back of my mind someone, you know, could challenge the whole process and seek injunctions, but that seems entirely rash and probably unlikely. So I think your first prediction is what I would think is right. Yep.
You'd have to be very careful not to anticipate a particular outcome, because when a matter's before the court will expect you to be cautious in terms of how you deal with anything that's touching on that matter. So you would have to have a sort of a layer of regard around anything that was interrelated. So that it would affect your process unreservedly, but how it would depend on all of those factors. We can't know until it happens.
There's just one other issue that I'd like to raise, and principally Mr. Cook or Mr. Campbell. The committee previously rejected staff's suggestion of an independent commissioner to oversee any of the housekeeping matters while we went through this process. We've talked in several places today about the hearings process. This council has qualified commissioners within its ranks. Is there an intention to use them, or is it a staff desire that we go outside because we're a small district and the possibility of conflict of interest, etc.? Can you give us any information on your thought processes there?
Thank you, Mr. Councillor Thompson. In our experience, and I've been talking to other councils and commissioners, independent commissioners around this, the experience in district plan hearing panels is that an elected member, at least one, is of value to a hearings panel. And also having an accredited chair is also important because of the length and type of material going through. But also to have a mix of expertise around the panel and drawing on commissioners that may have sat on sort of other similar sized rural councils is helpful. But yeah, there is certainly a benefit of having at least an elected member on a panel. And again, yeah, it depends on timing as well with obviously if hearings won't commence till after the next round of the local government elections, but whether do you have any opinion on that or Roger? But yeah, it's our experience that there's at least one elected member on those panels.
Mr. Cook.
Thank you, Chair. I was just actually going to refer to the point that Mr. Campbell ended on, which is really we've got an election process to get through as well, so we don't know which current elected members that are commissioners will be elected members by the end of the year, and until that's clear, we couldn't possibly make any conclusion or any recommendation or seek any guidance from council as to who they would like to see on that panel. It seems almost certain, though, that the panel will have to be constructed of some outside parties, just to get through the sheer volume of work and the expertise and knowledge that is needed, and the time frames.
Thank you. It's just I wasn't touting for work. I was simply because it's of public interest. It's something that should be canvassed.
Just on that comment, I mean, there's potential for ones who aren't going to be elected members after the election, but have the connection and the understanding of the situation to be on the panel as well, if they've got the accreditation. Just keep that in there as an option.
Oh, no, well, no further issues to raise around the table. Councillor Hopkins, what a surprise.
Well, no, Mr. Chair, as you rightly pointed out at the start of the meeting, this is a workshop and therefore no decisions can be made. We've teased out the three options. I don't propose to signal at the moment which I favour, but I think we've had an opportunity to construct for ourselves a hierarchy of preference. The real question is, when is the matter going to be resolved? Because if some of the arguments we've heard this morning from Mr. Campbell and from Michael and the team from Anderson Lloyd are correct, this 2-year ticking time frame is actually impinging upon us. And if we are to do anything other than proceed as we currently are, the sooner we make that decision, the better. So at what point is this now going to become a matter that goes directly to council? Will it be is it our view that that's how it should proceed? Do we need to schedule a meeting of this committee to vote on the matter and produce a recommendation to take to council? And if that's the case, what's the time frame?
Good question, councillor. My right as chair is to seek reconvening of a DPR subcommittee meeting, which I will be discussing with Mr. Cook at our adjournment.
Right, excellent. So that might happen quite soon.
Well, I believe that you're right. It needs to happen sooner than later.
Yeah.
Well, thank you very much for those who have watched online and for those who have attended. Again, I reiterate, we do appreciate the level of interest in this, the angst it is causing, and we don't want it to continue any longer than necessary. I'll declare this briefing closed.